Well, joining us to discuss the contentions from both sides in the Moyane inquiry, our political analyst, Professor Sipho Siepe. We have Mr. Tom Moyane's defense lawyer, Eric Mabuza. We also have Advocate Zola Majavu joining us via Skype, as well as Paul Ngobeni, legal expert, over the phone line. A very good evening to you all, and thank you so much for joining us. Perhaps let me start with you, Mr. Mabuza. Just talk us through what Mr. Moyane's thoughts are regarding the fairness of the Nungent Commission.
Thank you for inviting me to your studio. Of course, Commissioner Moyane has also read about the new revelations that Commissioner Nungent has met with Minister Pravin Gordhan before testifying. He is quite shocked, to say the least. This is not something that he expected of an experienced judge, retired Judge Nungent, to have done. You'll remember that Commissioner Moyane has always complained, and his complaint has always been consistent, that both the disciplinary inquiry as well as the Sars inquiry were unfair against him. You'll also have remember that one of his complaints before the Sars inquiry is that he was not invited to attend the inquiry, nor was he consulted by the evidence leaders to come to the inquiry. So now we have this revelation that not only did Minister Gordhan meet with the evidence leaders, in fact, he met with the judge himself. We don't know what they discussed. We don't know the circumstances under which they met. It's quite something that it's unheard of. You'll also remember that during the proceedings on the 29th of June, our counsel advocate Dalimpofu specifically asked the judge to clarify how witnesses were chosen and who chose the witnesses. We didn't get any proper response from the judge. In fact, that would have been an appropriate time for the judge to come out and clarify the issue, to say, in fact, I must put it on record that I have met with Commissioner Nungent, with Minister Gordhan, but that was not explained to us. That's why these revelations are quite shocking. I'm sure you can ask any lawyer, you can ask any political analyst, they will be able to tell you that it is unheard of.
We do have a legal expert actually on the phone line, Mr. Paul Ngobeni. Is this unheard of that commission chairs get to have meetings with witnesses before they testify in a commission?
Absolutely. It is actually shocking. It's unheard of. If you can just think about it, the commissioner, at the end of the entire commission hearing, he's going to have to make credibility determinations on the testimony of some of the witnesses. Now, if he already shows partiality, where he meets with some of the key witnesses, ex parte, outside of the hearing process, and ironically, he meets with people who are going to be making adverse comments about Mr. Moyane, but Mr. Moyane is not given the same opportunity to meet with the commissioner. That clearly establishes bias on the part of the commissioner. It established appearance of partiality, that he's already taken sides, he's already determined who his buddies are, he's already determined who he's going to believe. So, and by his actions, even the fact that there is discriminatory a decision to exclude Mr. Moyane. Why is Mr. Moyane not given the same opportunity to meet with him and to clarify some of these preliminary issues? And you may recall, very recently, there was a criticism of the public protector by Judge Cynthia Pretorius in the CIX matter, where one of the criticisms leveled at the public protector was that she met with someone from the president's office, not even the president, just someone from the president's office, and did not afford the same opportunity to other persons, interested parties such as APSA and all of that, that they were not given equal opportunity to meet with her. So here you have a commission headed by a judge. At the end of the day, he's still going to be an adjudicator. He's going to make he's going to determine certain facts, credibility of witnesses. Now, if he's already decided who his witnesses are and who are more credible and who deserve to meet with them and who doesn't deserve to meet with them, then the whole thing is tarnished. It's a farce. It's a joke.
Well, let's get another legal voice here in the form of Mr. Zola Majavu. Good evening to you and thank you for joining us. What's your view?
Good evening, and good evening to my colleagues and to all the viewers out there. Firstly, I think I'm personally constrained to cast aspersions at this stage without establishing the real facts surrounding that meeting. On the face of it and what is put in the public domain, it does appear to be unusual, and I agree with my colleagues on that score. But I think I would have been a lot more comfortable had that discussion with Minister Gordhan been conducted by the evidence leaders, because that is their place to make an initial determination on whether or not a particular witness is relevant and to what extent that particular witness's testimony may be led. But if that discussion happens with the commissioner himself in the form of a judge, in the absence of either the evidence leader and other parties' legal representatives, it does point to some form of irregularity. But I'm saying, subject to qualification, I think Mr. Mabuza is in a better position to have fired off a letter to the judge to demand a full account of the circumstances around which this private discussion has happened. It may well be that there was or there is nothing untoward with that, provided the same process or approach will be followed with other subsequent witnesses. It does appear a bit odd.
Well, just coming back to studio, Professor, do you agree that perhaps the location of the meeting and who was present in the meeting also plays a role in the credibility of the meeting?
Yeah, I think my colleagues are also being very polite. That it's not only about that the judges are sworn to impartiality, and the mere appearance of partiality is a problem. Actually, it tarnishes the whole exercise. Actually, the judge has actually compromised himself on this one. So it doesn't matter what he may disclose, because what he'll be saying is that we must actually take his word for it. And let us also affirm the humanity of our judges, that they are also human beings. And if he is interested in justice, he'll understand that there is also a concept that justice must be seen to be done. So and where you have a person who's appearing before you, raising a number of issues, and those issues are actually material. First of all, my colleagues are also saying there's an element of irregularity, but they want to say because he's a judge, maybe. But the point is, he's a human being, and we've seen judges erring a number of times. The reason why we also have appeal processes from the High Court to the Supreme Court of Appeal to the Constitutional Court is because we accept that judges are human beings, and they're also prone, or they are more likely to also make mistakes. We build that precisely because we assume that. So where you have no process of appealing, and where you have a judge who's experienced and retired, you would expect that he would have been very careful about a matter that is as grave as this. So that's the first thing. But this does not come on its own. It comes also with other concerns that have been raised. For instance, here you have a president subjecting a person to a number. There's a DC, there's also commission of inquiry. And the senior counsel representing the commissioner raised the issue, number one, of saying there's an issue of double jeopardy. I'm not a lawyer, but that is a known principle, that you don't do that. And he should have actually raised that issue with the president, that Mr. President, there's this issue. Then the second thing is, you have somebody who's going to be, who is a material witness, and who has a personal dislike for the commissioner, somebody who used to be there. And when this is known, you will know that there's already a credibility problem. And it does not mean that the only person who knows about Sars is only one person. And besides, you have this person who is no longer a minister of finance. you would have expected that when he left the Treasury, he was not taking the office with him. If the judges wanted to know how this works out, and also being aware that there's no love lost between the two, he would have been more careful to say, let me have somebody at Sars to explain how Sars works. But instead, he gives us some weaker explanation, as if the only person with an understanding of Sars is a former commissioner. So I think that is, so this must be seen in the totality of that. But the point is, this judge, if he believes in fairness, he should actually say, I don't think I've acted well. Then there's also, in addition to that, the senior counsel of Moyane raises the issue that within the panel, the people are going to make an adjudication is a person who is known to be a friend of the president. And this is not disputed, but is not considered to be material. So you can see that the entire thing has been choreographed, or at least I see it as choreographed to produce a particular outcome. So I do think this retired judge must do us the honor to simply say there are just too many concerns that are being raised, and maybe I should look into myself. But I don't come from a view that says the judges are infallible. I start from the fact that they are human beings and they have erred, and it can be demonstrated many times. And our system also operates with that understanding that the judges are also human.
Mm-hmm. Now, Mr. Mabuza, has the judge perhaps written an official letter to explain the meeting? Because, I mean, according to him, the meeting was above board. Is this something that has been a communication between Mr. Moyane's legal team as well as the judge?
Well, you'll appreciate that the revelations only came out yesterday, and we still have to consult with Mr. Moyane to take instruction on the way forward. But the most likely course of action that we will do, we'll write to the president to raise our concern and ask for the president to remove him so that we don't have any further wastage of taxpayers' money.
Mm-hmm. And speaking about writing to the president, Mr. Moyane mentioned that he would be writing to the president to ask that the commission of inquiry and his disciplinary hearing don't happen concurrently. Is there any feedback that you have for us on that matter?
You would have seen that the president has said he would await the ruling of Advocate Bam, who's chairing the disciplinary inquiry. So we're just going to add this to the further issues that he has to take into account before making up his mind. Just to make one point, imagine if it came out in the media that Judge Zondo, who's heading the state capture inquiry, met with President Zuma. Can you imagine the kind of outcry that you would have out there? But, I mean, it's no different from what has happened. Mm-hmm. Professor Sepe is quite correct that what has happened is irregular. It's irregular, to put it mildly. It compromises our people's trust in the legal system that experienced judges do engage in such conduct.
So there clearly is a perception of prejudice being created here. Mr. Ngubeni, just address the issue of double jeopardy in Mr. Moyane actually standing before a disciplinary hearing as well as a commission of inquiry at the same time.
Well, that actually proves two things. One is that the president is sort of hedging his bets to say, if Mr. Moyane wins at the disciplinary hearing, they then have a fallback position which will be produced by the commission headed by Nungent, and that they will use that commission to then, if it makes adverse findings, to then get rid of Mr. Moyane that way. It's also just doesn't make sense to hold two concurrent hearings involving alleged wrongdoing by the same person. This notion that the president is going to await the outcome of the BAM inquiry. If BAM comes out, Advocate BAM's inquiry ends up in acquittal for Mr. Moyane, he finds out that Mr. Moyane did nothing wrong, I don't see why there will still be a need for a commission that will be looking at Mr. Moyane's performance. I mean, we are not fools here. Let them treat the public as fully intelligent people who understand what's going on. Mm-hmm. You have a situation where Mr. Nugent, the Judge Nugent, was appointed by the head of the executive. That is the president of the country. Now, Mr. Gordhan is currently a minister in Ramaphosa's cabinet. So to then go and meet with a member of the executive, a colleague of the same person who appointed Judge Nungent, and say, well, there was nothing wrong, we really didn't discuss anything substantive. I think they're taking us for a ride.
Now, Mr. Majavu, is the Nugent inquiry panel actually choreographed to produce a certain predetermined result, according to your view?
I am in no position to say that, but I am sufficiently concerned by the allegations that are emerging, which on the face of them point to an irregularity that, if found to be established, it may well taint this inquiry. I just wanted to make a quick point and indicate that where I part ways with my colleague, Mr. Mabuza, is where he suggests, and I respect his point of view, that they would rather write to the president and ask for either a discontinuation or a recusal of Judge Nugent. I would have thought that the better route would be, because these revelations came out through the media, firstly, formally write to Judge Nugent and demand an explanation on record regarding the circumstances pertaining to this private meeting, so that upon receipt of his explanation on record, then they take instructions from their client to then be able to determine what the way forward would be. At this stage, these things have been bandied about in the media, and I'm just concerned that they may be squandering an opportunity to establish the true fact. Because if it is indeed established that that discussion happened as reported in the media, then they will be in a better footing to then go to the president and say, we believe that the person whom we have appointed to head a commission has behaved in a manner that we believe raises a reasonable apprehension of bias. Then at the very least, they would have, exhausted all remedies, because at this stage, Mr. Mabuza says these allegations only emerged over the weekend in the media, and he is quite right, which is precisely why he then needs to put Judge Nugent on the spot with respect to say, Judge, this is what has been attributed to in the media. Can you please explain these circumstances, mindful of the preliminary issues that they raised at the beginning of this inquiry? Because if they are found to be correct, then I'm one of those people who will add their voice to the chorus that says the judge may end up having to consider doing the right thing, which is to step down. It's not about whether or not he misconducted himself, but it's about saying these facts have not been adequately established, but I'm sufficiently troubled by them, and so should Mr. Mabuza.
Mr. Mabuza, let me just give you a right to reply. Do you think that it is a better route to perhaps get the judge to maybe respond in writing first?
No. I think my learned friend does not have the context, and I respect him a lot. But you'll remember that when we raised the recusal of Professor Katz, the judge said he could not recuse Katz because he was appointed by the president. So there's no point in going to Judge Nugent to raise the issue, because he'll simply say he was appointed by the president. It's for the president to remove him. So we're going to the decision maker to ask him to remove him. In any event, Commissioner Nugent has already placed his version on record in the media as reported. So the issues are there. He admits that he's met the Minister Praveen. So we're just going straight to the president to ask him to look at this issue properly, because it's concerning. That's why we are having this debate here, because the public is concerned about what they see or perceive to be unfairness against Mr. Moyane.
Well, it's actually better to do that, cut all the red tape and go straight to the decision maker. Professor, just rounding off your closing statements.
Well, I mean, there are three issues. One is the issue of double jeopardy, which is called double dipping, which actually indicates that there is an executive posture that says whatever happens, the man must go. So it is not about the issue of fairness. So that's the first thing. Second thing is that you have somebody who has been appointed by the president, the Minister of Public Enterprise, who then has to go in and testify and ensure that the outcome that the president may want, he gets. He will not go there knowing full well that he's employed by this person and undermine that. So there is that aspect. Three, there is also a personal vendetta or dislike that exists that Praveen has actually shown towards the commissioner. So you don't bring a person like that, because that begins to raise the issue of credibility. But then the last one is the one of a friend who, and when somebody says, but this person is a friend of the president, in the same way that he will not want to offend the relationship, in the same way that Praveen will not want to offend his relationship with the president. This judge should have actually say, given these realities, I think I must recuse myself, and I must also address these other issues that are principled in law. But what we have here, the determination for him to continue, actually give credence to those people who are saying this commission is intended to achieve one outcome, and it doesn't matter. But what is worrisome is when the minister meets with the judge, and there are no other people who are listening, especially when you are called. And also, as the lawyer indicates here, that the question that was also asked, who has decided who should be the witnesses? It could be just during that process. Praveen could have chosen people that he knows also have a dislike for Moyane, and who will then be coached to come up with a particular posture. So this thing, given all this number of concerns, I think if the honorable judge should actually do the honorable thing to say there are a number of concerns that have been raised, and in the interest of justice, and also in the interest of that justice must be seen to be served, and in the interest of impartiality, I don't think I can continue.
Well, Mr. Majavu, your closing statement, please.
Very quickly, I'm happy to accept that as lawyers we've got different approaches and strategies, but I would have thought that with respect, Commissioner Moyane at the very least deserves the benefit of a written account from the judge himself on account of what is attributed to him before you go straight to the decision maker, so that at the very least there is a record of what he himself says, as opposed to rushing straight to the decision maker based on what is reported in the media. But I'm not going to debate strategy with my colleague. I'm happy to accept that I could be wrong, but I still think Commissioner Moyane deserves a written account from the judge.
Mr. Ngobeni, closing statements?
Well, I think the credibility of the entire commission is at stake, and the president has a choice to make. If he wants the commission to have a credible outcome, then he's going to have to do the right thing, which is basically to ask Judge Nungent to step aside so that you have a more credible person, a credible judge, who can start the process and let it have the legitimacy it deserves. Otherwise, the commission is hopelessly compromised, irredeemably compromised. And there's no point in talking about other things involving the Nugent meeting with witnesses and so forth. An adjudicator does not meet with a witness outside the hearing process before the hearing process starts. When that same person is meeting with is going to be testifying, and his credibility is going to be assessed by the same adjudicator. It doesn't happen.
And lastly from you, Mr. Mabuza.
I think what should happen is that the presidency and the people who advise the president must take a step and look at what is happening, whether it's in relation to the disciplinary inquiry, where they want the evidence to be taken on paper, or whether it is in relation to the Sars Commission, to say, hang on, there's something that's not right here. Let's try and resolve the problem. Let's try and revisit the problem, because it does not seem to work. It's been one problem after the other. You'll remember there was a recusal of Justice O'Regan. Now there's a complaint about Commissioner Nugent. There's a complaint about Professor Michael Katz. It's just unending. It's not moving. We have not moved. It's been 5 months since then. We have not moved a step further. So I think the decision makers need to revisit the issue sensibly and with a dispassionate view, and look at whether there's another way to look at the matter, because as I say, it's not working.
Thank you very much to our esteemed panelists. That brings us to the end of our bulletin. The conversation does continue online, so follow us at Afro Worldview. My colleague Harold Babalam was up next with Prime Business. From myself and the Primetime team, Salang Litsokfetsi.